broadcast is now starting. All attendees are in listen-only mode.
Welcome to today's webinar, everyone. I'm Anna Hobson from HR Simple, and I will be moderating today. Today's presenter is Emily from Fredrikson Byron. The presentation today will be about an hour long, and if you have any questions, please submit them into the question box, and she will get to them at the end of the webinar. If you'd like to view any other webinars from ourselves or our partners, you can go to hrsimple.com/events, and we have those listed for you. HR Simple provides federal and state-specific manuals. We make law employment easy. Our books are written by top labor attorneys and cover topics such as vacation policies, employee documentation, and how to fill out the I-9 form. You can go ahead and view these resources at hrsimple.com/shop. So today's presenter is Emily from Fredrikson Byron. She's an experienced advisor and litigator for employers. She defends employers against allegations of sex discrimination, age discrimination, race discrimination, FMLA and ADA violations, wrongful termination and violation of public policy, and tortious interference. To help employers maintain a productive workplace and avoid litigation, Emily partners with clients to provide supervisor and manager training, investigate internal discrimination complaints, provide reasonable accommodations to disabled employees, and navigate issues surrounding family and medical leave. So on that note, I'm going to pass things over to Emily so we can go ahead and get the webinar started.
All right. Thank you very much. And Anna, can you see my slide?
Looks like it's still loading. Don't see it quite yet.
Okay, there is a thing that says you've been made the presenter and when ready, show screen. So I will click on that. I just saw that.
Okay, perfect. It looks great.
Okay, wonderful. Hi, everyone. Thank you, Anna, for that introduction, and thanks to all of you for tuning in today for this presentation about employee handbooks. I have been litigating employment cases and advising employers for about 15 years now, and I have worked with employers who have really gigantic handbooks that cover every imaginable topic, as well as employers who provide employees with essentially a one-page handout with basic work rules. There are certainly numerous resources and tons of vendors out there available to help you organize and build and revise your employee handbook. So I will not be providing an exhaustive list of every policy that you should include. And really there's no one size fits all. It really depends on your particular situation. So instead, I'm going to talk first about 5 policies that address the most critical legal risks in the employment relationship, as well as some additional areas I think a handbook should address. Second, we'll talk about some new considerations that may compel you to add or revise your current handbook policies. And then third, just some general guidelines, things to keep in mind when you are creating or revising a handbook. So in addition to litigating employment cases on behalf of employers and advising employers regarding compliance with the law, I also assist my firm's mergers and acquisitions group by conducting due diligence reviews of employment issues when a client is buying another company. So these next few policies are the policies that are really front and center when I review a target company's policies and practices, because they indicate whether or not the target company has taken steps to reduce the risk of liability in the employment categories that can result in the most liability or the most reputational risk. So let's go over some of these big 5 policies that are the biggest areas of legal risk. First on this list is always to find out if the employer has an at-will employment statement and a contract disclaimer in its handbook. This is a statement that the employment relationship is at will, and it often comes right at the beginning of an employee handbook. Sometimes it appears several times. Most commonly, statements regarding at-will employment say something like this. This handbook is not a contract. Employment is not guaranteed for any specific duration. The employee or the employer may terminate the employment relationship at any time for any reason, with or without notice. Similarly, the employer may change your job title, duties, responsibilities, compensation, benefits, and other terms or conditions of employment at any time. The at-will employment statement is usually repeated a few times in a handbook and in other employment forms and documents, just to make sure that no other policy accidentally contradicts the at-will employment policy. For example, a restatement of at-will employment may and should appear in the company's offer letters. It may also appear on the form that you use for performance improvement plans. Because some employers issue PIPs, performance improvement plans, that provide a period of time, such as 30 days or 90 days for the employee to show improvement. A statement about at-will employment is important here so that it is clear that the employer is not promising employment for that 30 or 90-day period. My advice to clients is to issue performance improvement plans that require 1, immediate, and 2, sustained improvement, and to not include any specific period of time, like 30 days or 90 days. Because we don't want an employee to improve and be a model employee for 90 days and then revert back to the same old performance issues, and then we think we have to start all over with a new performance improvement plan, instead of just saying, okay, well, they improved, but they didn't sustain the improvement, so now it's time for discipline or to terminate employment. So usually if there is a at-will employment statement on the PIP form, it will say something like, this performance improvement plan does not alter the at-will employment relationship. And by the same token, if you were to include that, even if you don't have that duration, even if you have the recommended language, it's clear that just because you improve immediately, and just because you sustain that improvement, also doesn't mean that you're guaranteed employment for any period of time. At-will employment statements also appear in communications about wage and salary increases. The best practice in an offer letter or in a a pay raise memo is to list pay per week or per month or per pay period, and not as an annual amount, to avoid inadvertently promising employment for 1 year. So why is this at-will employment statement in the handbook such a big deal? Well, when things are going well, people sometimes say things and make promises they should not make. So if a manager or supervisor promises an employee a promotion, or that the company will not fire the employee for certain conduct, the forceful at-will statement in the offer letter and in the handbook is a quick rebuttal if that employee is terminated and claims breach of contract. So these are simple statements, and I'm sure you have all seen them. Make sure these statements are included and that they do not get eliminated in the interest of shortening the handbook at that next revision meeting when you're talking about issuing a new version of the handbook. Authorization to work in the United States is also a big risk area. No employer wants to be in the position of being nervous when a government agency decides to conduct an audit. Well, let me take that back. You're going to be nervous, obviously, but you want to know that you have done everything you could to be in compliance. Lots of employee handbooks do not include this information because it is seen as a pre-hire issue. But this process of verifying eligibility for employment occurs within the first 3 days of employment, most routinely. And a new employee will be terminated if that employee cannot comply. So I think it belongs in the handbook. Also, handbooks most certainly are for employees, but they also serve to remind management and human resources of their responsibilities. This is an area where I recommend the handbook include specifics about what documents must be presented, who will examine the documents, how the Form I-9 will be filled out, and how records will be maintained. I-9 audits often reveal that employers have been making routine errors when it comes to verifying authorization to work in the US. A thorough policy that includes the details and that is in the employee handbook for everyone to see is a really good way. Oh, and also updated to comply regularly with DOL rules is a good way to build in some accountability to reduce the risk of a process that might be unfair to employees and provide confidence when the government comes knocking. And a statement that employment is contingent on providing documentation of eligibility to work in the US should also be in your offer letters to new hires. All right, let's move to the third of my big five, and that is pre-employment drug testing, drug-free policies, and all pre-employment screenings. Many states are extremely stringent when it comes to drug testing in the workplace. Many states also require that employers distribute a compliant policy if they plan to test. Handbooks and offer letters should clearly state that employment and that offers of employment are contingent on the results of a drug screen or whatever the pre-employment testing is, including a background check, for example. Beyond testing, your handbook should include policies regarding alcohol that make sense. So if your company has events where alcohol is served, make sure there is an appropriate carve out for those events, but not such a huge carve out that you cannot take disciplinary action if drinking at an event leads to someone being impaired in a work setting. Even the holiday party, of course, is a work setting. Now more than ever, the workplace is not bound by any specific place or any specific time. So office holiday parties, if any of those are happening even, are not the only concern these days. So consider whether your policy handles a situation where an employee is impaired, say, while on a video conference with a direct report or while texting with a client. In states with highly technical drug testing statutes, such as my own, I advise clients to go ahead and have a policy that allows drug testing if they want to have the ability to do it, and to make sure, of course, that it complies with the law, but to carefully consider whether a situation requires drug testing before they take the step of doing a test. In many cases, it's really not necessary to do a drug test or to screen for alcohol, because the conduct by itself, regardless of whether it was caused by being under the influence, warrants disciplinary action. And as soon as you drug test, then you bring that entire force of the drug testing statute and everything, the drug testing policy, under the scrutiny potentially of the courts. And I just wanted to add another note about drug testing and about alcohol and drugs. If you do have employment contracts with executives, so executives that are not at-will employees, make sure that impairment due to alcohol or drugs and any usage of illegal drugs at work or on personal time are reasons to terminate for cause. Now, excuse me, I'm going to do a little bit of a PSA here. Finally, I think this is a really great time for employers to take a look at what you have in place to help employees who may be having issues with substance abuse or addiction. I think we've all seen that employees' mental health has taken a hit in the last year and a half, and it's I think it's kind of common knowledge, certainly no secret, that people sometimes choose to self-medicate with alcohol and other substances when they are suffering from depression or anxiety or other issues related to mental health. Layering on top of that, we also have a bit of a labor shortage in many places. So this is a great time to try to be a hero for your employees, to try to retain and support them. So if you're looking to be that hero, this might be a good time to fortify your benefits, to provide more access to counseling and other resources for addiction, both for the employees and for their families and dependents. It's not the right choice for every employer, but I certainly am working with a lot of employers who are having trouble hiring and retaining employees, and this is one area where you might find a need that you can fulfill. Okay, so that brings us to number 4. That's wage and hour policies. Wage and hour mistakes can be an employer's largest uninsured risk, and prevention, in my view, really starts with your employee handbook. I advise employers to include quite a bit of law in their wage and hour policies in their handbook. And this is not necessarily a policy that's going to be labeled wage and hour. This is probably a collection of policies, overtime, exempt and non-exempt employees, kind of the definitions of who they are. I really like a policy that defines what is meant by exempt and non-exempt, potentially, depending on your employee population, even getting into what makes a position possibly exempt from the FLSA. And I like a policy that explains when overtime must be paid. I think this is a case where prevention is the best cure. And if employees are aware of when they are deserving of being paid overtime, that is the best thing you can do to shield yourself from a lot of liability later. I think knowledge is the right way to go here. It is certainly fine to require non-exempt employees to have permission to work overtime. It's fine to have that in your policy, but if they fail to get that permission, they must be paid the overtime rate for the time worked. And I think that should be explicit in the policy. You will be paid for every hour of work. Our rule is that you must have permission to work overtime. If you do not get that permission, you may be disciplined, but you will be paid for every hour worked, and you will be paid the overtime rate for any hours worked over 40, just with the caveat that there's at least one state that I'm aware of, there may be more, where sometimes overtime is owed if someone works more than a certain number of hours in a day. So obviously always look at your particular state laws. Your handbook should be very explicit about how time must be tracked, who has authorization to make changes to time records, and disciplinary consequences when the rules are not followed. Because the FLSA and other wage and hour laws are so technical about penalizing employers when they don't follow the law, I think your handbook needs to be just as specific and technical about disciplining employees when they don't follow your policy. Because that policy and employee behavior that it incents is your backstop against wage and hour liability. Employees who supervise others need to be trained on the importance of compliance, the importance of paying employees for all time worked, and the risks of non-compliance. There are a few exceptions to Fair Labor Standards Act and state law minimum wage and overtime rules, but there is no exception just because an organization, an industry, or a particular supervisor has historically allowed off-the-clock work. So I have an example here, and this may not speak to your particular organization, but I think it's a decent illustration of how important it is to comply with wage and hour law, why the liability can add up, and why it's so important that your handbook policy kind of meet this challenge. So if, let's say you have a part-time employee, maybe this is a college student who is very ambitious, is trying to get a foot in the door, and let's say he is paid $10 an hour, and he's supposed to work 20 hours a week. So with that, he would make $200 a week, or $10,400 a year. I didn't recheck my math, so please don't test me on this. Please don't check. But let's say the employer is not tracking the time. They're just going to trust this person, this college student, to track time. Don't work any more than 20 hours a week. We're just going to pay you $200. Okay. And the employee goes ahead and works off the clock because the employee wants to get ahead, wants to impress the boss, wants to get a job after graduation. So there could even be a supervisor encouraging such behavior. You know, oh, we got this big project, you know, I'm going to be really impressed if you can get this done. And no one's even really thinking about the rate of pay or the hours limitation. Because, you know, this college student has really become part of the team. And everything is fine until you fail to hire this person full-time when he graduates. And he gets mad and he hires an attorney to sue for all those unpaid wages for the past 3 years. So for the purposes of this example, if that employee was actually working 40 hours a week, that would be $10,400 in straight damages per year. Okay, just paying him what he actually worked. But we have a 3-year look-back period if it was willful. And that might be, so that would be $31,200. And it's doubled because that's what the statute says. So it's actually $62,400. And under the FLSA, the employer is also responsible for the employee's attorney fees. So you might end up doubling that. And the employer's attorney fees have to be paid too. So maybe we have to triple that $62,400. And now we are at nearly $200,000. And remember, we're just talking about one employee. So what if you had 5? What if you're in a college town, you hire 5 people in the same academic program? So now you're looking at close to $1 million in liability. And supervisors can be held personally liable for violations of the FLSA if the supervisor is instrumental in causing the violation. And this is why this can be an employer's single largest uninsured risk. Most EPLI, employment practices liability insurance policies, don't cover this. So make sure your handbook clearly explains time tracking for non-exempt employees and the importance of paying for every hour worked and overtime rates when required. This is not an area where you want to try to get a bargain and have people working off the clock. I apologize, it took a lot of time, really drove that one home because it's very important and something I want to make sure is in your handbook and is in your handbook with some detail. Okay, so finally we are at number 5. Now we're talking about discrimination and harassment and non-retaliation and disability accommodation. Your handbook must address each and every bullet on this slide. My preference is that each of these 6 things be in bold type or underlined. They each deserve at least their own paragraph or more, so there is no mistake that you have addressed all of these things. If your organization is in multiple states or you're thinking of being in multiple states, you always need to check state law and stay up to date on state law to make sure you address the protected classes and other requirements in each state, including any required training. I'm sure some of you are in states that have specific requirements about the type of training you provide about harassment, discrimination, and retaliation. You will notice that I have sexual harassment as a separate bullet. This is important because it's treated differently. Sex harassment is the only form of protected class discrimination that has the separate category of quid pro quo or this for that harassment, where someone with authority conditions any employment benefit on the employee permitting or participating in behavior based on sex. So your policy should specifically address this, and the best way to do it to make sure that you have done your duty in this area is to address sexual harassment separately. I also want to call out the last thing on this list. Retaliation probably deserves its own slide, if not its own hour-long presentation. More and more plaintiff side attorneys are suing only for retaliation. So they leave out the sex discrimination claim or the age discrimination claim and just have the retaliation claim. So they don't have to prove the employer discriminated on the basis of sex or age in a particular decision. They just have to prove the employer took an adverse action and in retaliation for the complaint of discrimination. So when the employee says, hey, I need you to look at this, I think I was discriminated against on the basis of my age, and then the employer does something or terminates employment, whatever, within some period of time, the employee doesn't have to prove that they were actually discriminated against on the basis of age. They just have to prove there was retaliation for the complaint of age discrimination. And the damages potential is the same, even without any proof of discrimination based on protected class. So yeah, let that sink in a little bit. They don't have to prove that you did anything adverse based on a protected class. They just have to prove that human nature maybe prevailed and that you didn't like the person anymore after they complained that they were discriminated against based on a protected class. So I think this is a really important thing to make sure you address very carefully in your employee handbook. Okay, so this is all part and parcel of big policy number 5. Your anti-discrimination, anti-harassment, and no retaliation policies are only as good as your complaint reporting procedures. So your handbook must outline how to safely report policy violations. Instructions to report to your supervisor are not enough, of course, because employees need to have a direct line to leadership and to human resources if needed to safely report something. Of course, we're thinking about the scenario where the supervisor is the one who's discriminating or harassing. I also advise employers to have an employee hotline to a third-party vendor. So, and this is going to depend a little bit on the size of employer you are. So an employee can alert an employer to a situation without identifying him or herself. And no one likes anonymous complaints. And it's always easy to say that, oh, we can't do anything about it if it's anonymous, we can't investigate because we don't have facts, we don't know who to talk to. But I think it's better to know about the issue and see if you can draw out the complainant. I think that's better than not knowing at all, because bad things tend to not go away. They tend to get bigger. If someone's harassing one person, they're probably harassing others. And I think it's good for an employer to know about the issues so they can do something. So your handbook policy should include information about who is trained to receive reports. And when I think about training for supervisors, this is top of the list because I really think that first 5 seconds after an employee kind of gets up the courage to say something is really critical. I think those first 5 seconds are when the employee decides, okay, the company is going to be with me or against me. And if they don't get the reaction they're looking for when they make that report, they're likely to think they need to get an outside attorney or some other help because they need someone on their side. So in that first 5 seconds, I want to make sure that supervisors and managers and my clients say something along the lines of, thank you for telling me this. This was the right thing to do. We don't tolerate harassment or discrimination. You're not necessarily saying that the complaint of behavior does rise to the level of illegal harassment or discrimination, but you're saying the company doesn't tolerate harassment or discrimination. And then the next steps really depend on your organization. Let's go meet with human resources. If the employee waited until a time when everyone was super busy to decide to drop this bombshell, you might want to say, I can't talk to you right now, but let's find a time when we can talk. And if there are any safety issues that need to be addressed, do that immediately. It's worth dropping everything else. And the first questions, of course, are going to be about confidentiality, and you'll want to be able to answer those correctly by saying that we'll keep the information confidential to the extent that allows a full and fair investigation, and you want to make sure to mention retaliation. So, thank you. We don't tolerate that. Make plans for the next step and address any safety issues, confidentiality, and retaliation. Okay, so investigations. Oh, my light turns off automatically when I don't move. I'll try to be more animated. Sorry about that. I do not think a handbook policy needs to go into a lot of detail about the investigation procedure that your company is going to undergo. So, despite what is on the slide here about the components of an investigation, I think your handbook policy should just state pretty simply that all reports of harassment, discrimination, and retaliation will be investigated and appropriate action will be taken. because an investigation does not have to be complicated. You know, sometimes an investigation is talking to the complainant and talking to the respondent or the person accused of the action. Sometimes that's all you need to do a full and fair investigation. No one needs to call law enforcement. The FBI doesn't need to be involved. It doesn't always have to be that big of a deal. Other situations, of course, call for, you know, IT to get involved and pull emails. You may be asking to image people's cell phones if there's a allegation of inappropriate messages. You may be looking at computer activity. You may be pulling in other people who might have witnessed the behavior. You know, you have a point in the process where you may have to make some credibility determinations. Is this founded or unfounded? Documenting it all the way and an appropriate response. But if you put all of that into your handbook, and then someone comes and makes a pretty simple complaint and you're able to investigate it with, you know, 2 conversations in one day, you know, what's going to show up in that petition is I complained and they didn't do an investigation, they didn't do anything. That may happen anyway, but I just think it's important that your handbook policy not make any particular promises about how involved something needs to be in order to be called an investigation. Another, you know, before I move to the next topic, another thing is that you might want to mention in your policy that that the company or the organization may bring in a third party to do an investigation under certain circumstances. There's lots of cases where this might happen. It might just be because human resources or leadership doesn't have time to do an investigation and it needs to be done quickly. Or it may be that there's concern about a conflict of interest. And I think it goes without saying that if somebody makes a complaint of harassment about the CEO or the president, and HR is in the same chain of command and is ultimately reporting to the CEO or president, then chances are that human resources may have some credibility issues if they're the ones doing the investigation. Okay, so obviously there are a lot of other policies that most employers are going to want to include in an employee handbook. So these are outside those like big 5 risk areas, but still very important. So first of all, conduct. Most employers choose to have a list of things that violate workplace policies. You know, you're never going to be able to list everything, every type of conduct that may lead to an employee being disciplined or terminated from employment. So there's definitely a balancing act to be made here as far as whether you want to get really specific about some things, whether you want to be very broad about you know, any inappropriate conduct or you know, those sorts of things. You know, obviously you're going to always include the favorite attorney phrase, conduct including but not limited to the following, and then you have your list of things that are not allowed. You know, I notice a lot of times that employers make a distinction in their mind between misconduct and poor performance. So if you are making that distinction and you want that to be in your employee handbook, be clear about that. That, you know, you can have a list of bad behavior that, you know, it may include things like, you know, you're not allowed to burn candles, right? You're not allowed to cook tuna fish in the office microwave, you know, things like that. Or you're not allowed to, you know, obviously anything that might be construed as violence in the workplace or make threats. But then on the other side, you have work performance issues, you know, failure to follow the reasonable instructions of a supervisor with regard to a project. So I just bring that out to you. You know, it's one of those things that you might want to decide in your employee handbook. Do you treat essentially bad behavior issues differently than you treat work performance issues. I think lots of times it is a good idea to do that, because if it's a bad behavior issue, you may not want to, if it's lying, if it's lying on a time card, something like that, these are things that people probably knew were wrong when they did them, or they should have. So these are things that maybe don't require, a warning. And then, if you have a progressive discipline policy, you may not want to implement it in a case like this, where someone does something that's dishonest or is just, on the bad behavior side of things. Whereas if it's a work performance issue, we may be talking about performance improvement plans, we may be talking about coaching, and then eventually, if none of those things work, removing someone from employment. So again, just bringing up that issue as something to consider as you're talking about your conduct policies. There we go. So most employee handbooks include information about disciplining employees. And in reality, people often do not like to take the step of going through the official discipline policies, because it's time consuming. It usually involves some confrontation that we don't like very much. So we often kind of leave these things until we get to the review or the evaluation at the end of the year. And by that time, it's too late. So your disciplinary policy should include in it the possibility of informal coaching. And in a perfect world, we would be able to trust our supervisors and managers every time there was a lack of performance or a conduct issue. We would be able to trust them to say, okay, it's time for warning number 1. It's time for the verbal warning that needs to be documented. But in actuality, what we usually have is more of an informal email saying, I told you to do it this way and you didn't. And then, because we want to include that informal coaching in our policy, so that when things go bad quickly, we can say, oh wait, there was some informal coaching here. So don't tell me right now that you've never been talked to about this, or that you never received any discipline, because this is under the heading of discipline, and you received this informal warning or informal coaching. So that's what I would advise, that your disciplinary policy is pragmatic in that way. If you do have the kind of 3 strikes and you're out, or the progressive disciplinary policy, make sure to also allow for the reality of the situation, which is that a lot of these conversations are more informal, but we all leave them knowing that the employee needs to do something differently, and that the supervisor meant to convey that message. I think I'll probably reiterate this before the end of the presentation too, but I always like to make sure that when there is a progressive disciplinary policy, that it's clear that the employer does not have to follow that. That there are situations where you certainly don't have to have a warning, a second warning, and a final written warning before termination occurs. Every situation where there's discipline should include the language that further issues may lead to discipline up to and including termination of employment. Another kind of big category of necessary policies for an employee handbook is the safety and security issues. How are you going to handle driving if you have employees that are driving on the job? How are you going to handle violence, threats to physical security, and of course data security? All of these are, very in depth. We don't have time to address them all today, and they also are really fact specific, based on your situations, but definitely need to be included. And then just excuse the laundry list here, but other things you might want to include in your employee handbook: respectful workplace policies sometimes are useful, workplace relationships policies, Regarding the probationary introductory period, I see that a lot in employee handbooks. I personally don't advise including that because unless there's some anomaly of state law, employers aren't really allowed to treat new employees any differently than they're allowed to treat employees who have been with the company longer than 30 days or longer than 90 days. And I think there's just as much danger that the employee has a false sense of security after that period as there is a benefit to the employer of saying, well, this is just your probationary period. Working hours, schedules, confidential information, how we protect that at the employer, and that there's no expectation of privacy if the employee is using company resources to communicate those types of things. Dress guidelines, leaves from work, conflict of interest and ethics, the company's policy regarding employment references, usually that those all need to be referred to HR and that only dates of employment and last position will be provided. What happens when there's separation of employment, and of course the acknowledgement of the handbook that we like to collect from everybody. So I want to go through some new considerations, and these are things that may prompt you to say, we need to revise our employee handbook. We need to revise these policies. We need to add some policies. Because we are in a slightly different world than we were in a year and a half ago, for one thing. Okay. So I know those of you who are embroiled in human resources, remote work is the subject of about every webinar that you can sign up for. So I don't want to go into it with tons of detail. Other than to say, I think it's perfectly fine at this stage of the game if you're not able to provide employees with a lot of certainty about what your policy is going to be. But when you do get to that point, be clear as to whether remote work is based on position, whether it's permanent or temporary, whether it's subject to change, whether there are conditions on remote work. Can someone work remotely if they're on a performance improvement plan? Is this a right or a privilege? How much notice are you going to give an employee if they have to return to the workplace? There's just so many things to consider. And I want to go back. I want to make sure I didn't cause confusion. I think you need to have a policy and a communication right now, but it may not be the final word on what your company is going to do if we ever get to a truly post-pandemic situation. So I think it's fine to have a policy now, but just make sure to say, like, this is subject to change. You know, please don't move to Montana if you're not already in Montana, because we may need you to come back to the workplace at some point. This is not the time to make permanent changes like that and assume that it's all going to be okay. You know, we don't want remote work. Most companies don't want remote work to automatically become a reasonable accommodation, but it's going to undoubtedly affect these analyses. So going back to the disability accommodation policy that you're going to have, you know, take a look at that policy with an eye to where you're sitting on remote work right now. So, you know, you might normally have not required a note from a doctor about immediate accommodation, but now if employees are kind of pushing the envelope and asking for more work from home accommodations, that might be something that you want to start including, for example. Okay, and the vaccine policy. So, you know, the mandate that was somewhat recently announced includes fines of $14,000 for each violation, but there is an additional enforcement mechanism that would include higher fines if an employer willfully or repeatedly violates the mandate. And these fines could go as high as $70,000 for each serious infraction and $700,000 for each willful or repeated infraction. So, you know, we don't have all the details on this yet. So, you know, until we do, and if you're a private employer with fewer than 100 employees. Any policy regarding vaccines should include the following elements. Who is required to be vaccinated? Is it everyone, or is it only certain rules, maybe based on certain roles, based on interaction with the public or travel, those who can't work remotely? Does it include temporary workers, contractors, interns? Obviously, you have to include the availability of accommodations for sincerely held religious beliefs and for disabilities. And you may want to include another, on your form, if someone's asking for an exemption, other reasons. Now, you might say, well, why would I include that? We're only going to provide exemptions for sincerely held religious beliefs and for disabilities. That's a great point, sure. So why would you include any other reason? Well, including any other reason might entice the person who's going to claim a non-sincerely held belief or claim a disability that doesn't have anything to do with the vaccine. That other category might entice them to write down the truth, which may be, I had a client recently, they're aware that the employee doesn't have a sincerely held religious belief or a disability, but just is hesitant about getting the vaccine for other reasons. So having that other prompt on the form might get you information you need to more fully evaluate the request. And if you are going to require the vaccine, what proof of vaccine are you going to require? Just an attestation, yes, I'm fully vaccinated, or are you going to require them to submit the vaccine card that they would have gotten when they received the vaccine? And then you really got to sit down and decide, what are the consequences for non-compliance? When must employees meet the requirement? Is it just you have to have first dose by this point or be fully vaccinated by this point? And always a good idea, include non-retaliation in your policy. So I don't necessarily advocate having a COVID-19 vaccine policy in your handbook. I do think it's probably a good idea at your next handbook revision to include a policy. We'll talk a little bit about this if we have time, about how the company might respond to an emergency or certain situations, which could include an outbreak of infectious disease. And that from time to time, the company may implement a policy requiring a vaccine from time to time, and other health and safety requirements and protocols. So yeah, I don't think you necessarily need to put the COVID-19 vaccine in your handbook. I do think you want to think about having a policy that that includes that among other things. And just what we're talking about here. So also in a handbook, response plans for workplace violence, extreme weather, infectious disease, etc. And I wanted to bring this up too. A lot of clients are having issues with, a lot of employers are having issues with marijuana being legalized in some jurisdictions and not others, for some purposes and not others. So this may be something you want to, I should have mentioned this back in the drug testing section, I guess, but decide whether you want to alter your requirements and screening there, how you want to handle recreational versus medicinal use of marijuana, what kind of medical proof you want to have, and whether this is a situation where it's something you want to test for, or if you just want to discipline or disqualify for impairment. Okay. And new types of paid leave. For example, Massachusetts last week extended to April 1, 2022, the emergency paid sick leave benefits for COVID-19. Other states are doing similar things, not necessarily related to COVID, but adding paid sick leave benefits, adding leave for victims of domestic violence, adding leave entitlements for caregivers, etc. So this is a case of looking at all your jurisdictions and staying up to date and adding these things to your handbook. Some people like to have a separate handbook for every jurisdiction. I advocate having kind of the general statement that, and other types of leave is required by state law, and then kind of having another handout for folks who are in particular states, and making sure, of course, that your HR and management that deal with those states knows exactly what's required. All right, so just some general guidelines about handbooks. Know your audience. So you look at this list here, yeah, we're talking to candidates, new hires, we're talking to employees who have been here for a long time, management, supervisors, we're talking to our colleagues even in human resources, because the handbook is something that keeps us all accountable. And then if things go sour, your employee handbook is Exhibit A in terms of proving that you knew what to do and then holding you to it. So it's opposing counsel, it's the judge, it's the jury. So when you are writing your employee handbook, be thinking about all of these groups of people. And you want to set the correct tone. You know, talking about the Atwill employment statement, a lot of times, like, you know, the letter at the beginning from the CEO or the president, welcome to Acme Corporation. We're so proud to have you as part of the team. We can fire you at any time for any reason, with or without notice. I always think, I mean, yes, we want to have that Atwill employment statement, you know, front and center and make sure that it's clear. I'm not so much an advocate of putting it in the welcome letter. You know, I think we can have a welcome without saying, oh, and by the way, we're going to cut you loose whenever we feel like it. I think it's okay to wait till we get to the table of contents to add that. A lot of employee handbooks have a mission statement talking about the goals of the organization. That's great too. Just make sure you're not making any promises. I always cringe a little bit when that includes something like we're a family here at Acme Corporation, because it does kind of conflict a little bit with that whole Atwill employment statement, depending on how it's said. And you know, I mentioned it, the spelling, the grammar, the punctuation, because if we go back one slide, right, to all of these people who are looking at it, you lose a little credibility every time you misspell a word. You lose a little credibility every time your grammar punctuation is incorrect. And you don't want to lose that credibility with a judge or a jury. So don't let those things get past you. Make sure it's thoroughly reviewed. And also look for outdated references. When I look at an employee handbook, no offense if you're still using any of these devices, but if it references a Palm Pilot or a BlackBerry, or talks about, you know, getting your long distance telephone card to use a payphone when you're traveling for work, that's a sign to me that somebody's asleep at the wheel. So not a good look. And of course, whatever's in your handbook, you know, make sure it's up to date, and then make sure you follow your own policies. The benefit to a handbook is that, you know, people know their expectations. You're held accountable for consistent treatment of similarly situated employees. But if you don't follow your policies, again, that's something opposing counsel will definitely bring up. They didn't even follow their own policies here. So why wouldn't you follow your own policies? Oh, because you're trying to get away with something under the table. You knew what you were doing wasn't right. Whether it's true or not, the perception is there. So you want to make sure your policies are up to date and that you are following them. And I do like a handbook that preserves discretion, so that, again, progressive discipline should be optional. The company has the right to use its Atwill employment policy without going through, you know, steps 1, 2, and 3. Make sure that's optional. Make sure you always include compliance with other applicable laws, because laws change, and we can't necessarily, depending on how you do it, you can't necessarily revise the next day. Leave in language like it's a case-by-case determination. Sometimes we can't do it exactly this way, so leave yourself some room. The discretion of management, policies may change with or without notice, and this is not a contract. And when it comes to reviewing and updating, obviously, you know, we want to do it as needed. I think you have to do it every 3 years. So, you know, we're in 2021. 2018 seems like a lifetime ago. So, you know, the time goes fast, but it was a different employment world then. So I think you want to take a close look every 3 years. Maybe there's not a lot of changes that need to happen. And every policy in your handbook, in my opinion, should have a little note saying when it was last reviewed or updated, so that if someone says, wait a minute, did we update this policy after this law was passed? Like, oh, when was the law passed? When did we update it? Yes. And leave out information that will become outdated quickly. I don't think you want to. I hope we don't need to put a requirement in employee handbooks that masks are required. I hope that it's enough to have a policy in your handbook that says from time to time the company may need to implement protocols for public health and safety, which may include mask wearing or, et cetera. And then, of course, consider how you're going to communicate. Do you still provide a hard copy? What are the ramifications for updating when you do provide a hard copy? Do you want to just have it available on your intranet so you could make changes quickly? Do they have to come to HR? And how are you going to communicate changes and updates? And I don't think there's a one-size-fits-all answer to these questions. It really depends on your workforce, how you convey information, and how you want to communicate your policies and handbook to them. So that concludes my my presentation. And Anna, if some questions came in, I'd be happy to take a few.
Sure. So the first one we have is a company located in Florida with remote employees in different states. Do we need an employee handbook for each of the states and abide by each state law, or just the ones in Florida?
That is a really good question, and unfortunately it really does depend. So there are states who will not honor choice of law provisions. They're going to hold you to their non-compete law. They're going to hold you to their laws regarding leave or break times, etc. So if you have people, especially during the pandemic, who are working remotely, one policy you have to have in your company that needs to be communicated is, before you move away from your primary state of residence, you need to let us know, because there are some states, because first of all, either we have to research the law of that state and find out what laws are going to be held accountable to. And there may be some states where you say, no, we can't do that. We're not going to allow our employees to work remotely from state A because of the policies that may be so out of whack with what you do as a company, or put you at risk in terms of the restrictive covenants that you have in place for your employees. So if an employee is in a different state, you have to do the research. You have to speak to ideally you're going to speak to an attorney, an employment attorney with knowledge about that particular state, and make a determination about what you need to do for that individual employee.
Okay, the second question we have is, do we need to notify employees when revisions to the handbooks are made?
Yes, you do. So I think anytime there's a revision to the handbook, it's always easiest if it's on an employer intranet, where you can kind of push a notification. It's not a big deal. If the change to the handbook is, if you have a hard copy, you don't necessarily need to distribute one. I think it's enough to make a communication about what the change was, and then if anyone wants to view the entire handbook, it's available at, in the HR office. You can come get a copy or whatever. But yes, I think it's absolutely advisable to communicate changes to the handbook. Presumably, if you're making the change, it's because there are new responsibilities, duties, or obligations, and employees need to be aware of that.
And then the last question we have today is, how specific do we need to get with discipline and termination policies?
Yeah, this is an area where I really advocate leaving yourself a fair amount of discretion. When we were talking about the prohibited conduct listings, you want to allow yourself a lot of discretion. I recently looked at a handbook that differentiated between major conduct violations and minor conduct violations, and that you could only be terminated immediately for major conduct violations. And it doesn't always fit, because sometimes there's 30 minor conduct violations. None of them were major. So, you know, per the handbook, it worked to sort of tie the employer's hands. So I think that policy is about, you know, what rises to the level of termination of employment. You really want to make those pretty non-specific, just so that you have discretion, because you don't want a very specific policy about what conduct is terminable to essentially eviscerate your at-will employment policy or cast doubt as to the reasons why you were terminating that employee.
Alrighty, it looks like that's all the questions we had today. Thank you so much, Emily.
Thank you. Have a nice day, everyone.